Namaskar. Dear students, in this lesson, we shall try to understand the concept of product liability and how the manufacturers, the sellers and distributors etc. are made liable for any dangerous goods or products which are sold in the market. The liability of manufacturers, wholesalers, distributors and vendors for injury to a person or property caused by dangerous or defective products is called product liability. Product liability, being a part of consumer protection laws, refers to the recourse available to the consumers of products who suffer injuries due to defective products. It governs the liability incurred by manufacturers, wholesalers, distributors and vendors upon injury caused to a person as a consumer or his property due to their defective or perilous products. Generally, the manufacturer must comply with all specifications, warranty and conditions and meet the consumer's ordinary expectations. The objective of product liability laws is to protect consumers from dangerous or the releasing into the market the products that they knew or should have known were dangerous or defective. The most common types of product liability claims could be seen in the case of automobile components, medical devices, lawn equipment, children's toys, home improvement tools, medications including over the counter, that is OTC medications such as pain relievers which have been recalled in the past due to side effects or contamination. The product liability is so called as the liability of the stakeholders like manufacturers and sellers revolves around the product. A famous 1916 New York Court of Appeals decision, McPherson versus Big Motor Company, expanded the classification of inherently dangerous products and thereby effectively eliminated the requirement of privity, that is a contractual relationship between the parties in cases that involve defective products that cause personal injury. In this case, the Big Motor Company manufactured automobiles that it sold to retailers who in turn sold them to consumers. The plaintiff Donald McPherson bought a car from a dealer and was subsequently injured when the car collapsed during a drive. The accident was due to a defective wheel which the defendant Bic did not make but purchased from another manufacturer. Evidence indicated that the defect could have been discovered by reasonable inspection, but none took place. The plaintiff sued the defendant for his personal injuries, but the defendant claimed that it was not liable for the wheel manufacturer's negligence. The state trial and intermediate appellate courts ruled in favor of the plaintiff and the defendant appealed to the Court of Appeals, that is the highest court of New York. The court narrowed the issue to whether the defendant owed a duty to anyone but the retailer to whom it sold the car. In a majority opinion written by Benjamin Cardozo, the court affirmed the judgment for the plaintiff. Since the defendant was a manufacturer of automobiles that, if defective, are inherently dangerous by virtue of their existence, it had a responsibility for the finished product, which included testing its various parts before placing it on the market for sale. The manufacturer could not avoid liability based upon the fact that it purchased the wheels from a reputable manufacturer because it had a duty to inspect the car, which it failed to do so. The defendant argued that since poisons, explosives are comparable items that are normally used as implements of destruction were not involved, there was no imminent danger to the plaintiff's life. There was therefore no basis for the imposition of liability upon a manufacturer to a third person who was not a party to the contract between the manufacturer and seller of the dangerous product. The court rejected this argument, reasoning that if a product, when negligently made, poses a danger of personal injury, then the product is a thing of danger, since injury is foreseeable consequence of its use. Since the car had room for 3 persons and the retailer who brought the car from the manufacturer planned to resell it ultimately to the plaintiff, it could be expected that injury could occur to persons who did not purchase the car directly from the manufacturer. The failure of the defendant, the manufacturer of the finished product for sale to the public, to inspect the car, and in light of the other factors mentioned, rendered the company liable to the plaintiff who was not in privity with it. This rule of MacPherson versus Big Motor Company that eliminated the need for privity between a manufacturer and an individual suffering personal injury from a defectively made product became the majority rule in the United States and one of the fundamental principles of the law of product liability. Now, let us have a look at the product liability during ancient times. Laws aimed at the protection of consumers are not confined to modern times. Some prohibitions against adulterated food and false weights and measures are thousands of years old, such as those found in Old Testament, the Code of Hammurabi, and the ancient laws of India. European consumer protection statutes began to appear in the 15th and 16th centuries and were based on the principle of deterrence. For instance, vendors of adulterated milk in Austria were required to drink all of their own product. Similarly, French consumers were allowed to throw rotten eggs at those who had sold them. In United States of America, the Constitution empowers the Congress to fix the standard of weight and measures, and various state laws were passed to allow inspection of food, tobacco, liquor, leather, lumber and gunpowder, etc. During most of the Middle Ages, consumers were protected to some degree by the moral strictures of the Catholic Church, self-regulations by craft guilds and consumers' own knowledge of products and local sellers. The laws did not favor the consumers, but neither did they favor the seller. There was essentially no law covering consumer transaction. Gradually, the European kings oversaw a shift in legal doctrine that favored sellers in their efforts to encourage the growth of trade. The dominant rule of the marketplace became caveat emptor, or buyer beware. The supply and demand conditions that underplay the doctrine of caveat emptor and limited government intervention on behalf of consumers changed rapidly in the latter decades of the 19th century. product liability law provides the consumers with legal recourse for any injuries suffered from a defective product. It is estimated that millions of people around the globe are negatively affected by defective products, and that the manufacturers or sellers end up paying large amounts for product liability insurance as well as damages. It is said that the personal injury lawsuits in tort for monetary damages were virtually non-existent before the second industrial revolution of the 19th century. As a subset of personal injury cases, product liability cases were extraordinarily rare, but it appears that in the few that were brought, the general rule at early common law was probably what modern observers would call no fault or strict liability. In other words, the plaintiff only needed to prove causation and damages. A product is required to meet the ordinary expectations of a consumer. Therefore, responsibility lies with the manufacturers and the sellers to ensure safety and quality of the product as per description. This, however, has not always been the case. The theory of caveat emptor, meaning let the buyer beware, governed the general consumer law from 18th century up until early 20th century, where the lifestyle was modest and all the products that were locally made, and therefore, any consumer who suffered any damages from a defective product could directly confront the manufacturer, and the intervention of courts or legislature was not required. However, with the changes in the means of production and consumption, such as industrial revolution, technological developments among others have led to the development of products liability law due to the rise in issues arising out of defective products. Product liability laws arise from the common law theory of caveat venditor, which means let the seller beware. This theory places the onus on the seller for any injury suffered by the buyer due to the product or service sold by him. Now, let us have a look at the product liability under the Consumer Protection Act 1986. It is relevant to mention that under the Consumer Protection Act 1986, there was no specific and express provision relating to product liability. Section 2, clause 1, subclause D of the Act defined defect in relation to goods as under. Defect means any fault, imperfection or shortcoming in the quality, quantity, potency, purity or standard which is required to be maintained by or under any law for the time being in force, or under any contract, express or implied, or as is claimed by the trader in any manner whatsoever in relation to any goods. Similarly, section 2 clause 1 subclause R defined unfair trade practice implicitly referring to defective goods. Section 14, which dealt with the finding of the district forum, conferred powers on the forum to remove the defect pointed out by the appropriate laboratory from the goods in question, to replace the goods with new goods of similar description which shall be free from any defect, to return to the complainant the price or as the case may be the charges paid by the complainant, to pay such amount as may be awarded by it as compensation to the consumer for any loss, or injury suffered by the consumer due to the negligence of the opposite party, to remove the defects or deficiencies in the services in question, to discontinue the unfair trade practice or the restrictive trade practice or not to repeat them, not to offer the hazardous goods for sale, to withdraw the hazardous goods from being offered for sale, and to provide for adequate costs to parties. Thus, the old Act dealt with the product liability, though not adequately, and also the remedies therefore. Now, we have to discuss the product liability under the Consumer Protection Act of 2019. The Consumer Protection Act of 2019 replaced the erstwhile Consumer Protection Act 1986, and it came into effect on 20th July 2020. This Act incorporated the product liability theory as a statutory provision for the first time in India under Chapter 6 of the Act. Under Section 2, Clause 34 of the Act, product liability is defined as the responsibility of a product manufacturer or product seller of any product or service to compensate for any harm caused to a consumer by such defective product manufactured or sold or by deficiency in services relating thereto. It may be seen that the 2019 Act imposes product liability not only on the manufacturer, but also on the seller of the product subject to certain conditions under the law. More significantly, the 2019 Act enables any person to raise product liability claim by filing a complaint before the District Commission or State Commission or National Commission against the manufacturer or seller of defective product through product liability action under Section 2, Clause 35. The 2019 Act also defines harm in relation to product liability, which includes damage to any property other than the product itself, personal injury, illness or death, mental agony or emotional distress due to personal injury or illness or damage to property, and any loss of consortium or services or other loss resulting from a harm referred above. However, it does not include any harm caused to a product itself or any damage to the property due to breach of warranty conditions or any commercial or economic loss, including any direct, incidental or consequential loss related to it. The 2019 Act also sets out liability for different parties involved in selling a product as under: first, the manufacturer's liability. Section 84 of the Act provides that a product manufacturer shall be liable in a product liability action if the product meets any of the following criteria: containing a manufacturing defect, defective in design, it has deviation from manufacturing specifications, it does not conform to the express warranty, it does not contain appropriate instructions for proper usage to prevent any harm or any warning against improper or incorrect usage. Further, a product manufacturer shall be liable for defective products even if it is proved that they were not negligent or fraudulent in making the express warranty of a product. Coming to the product service provider's liability, he shall be liable in product liability action in any of the following circumstances: providing faulty or imperfect or deficient or inadequate quality, nature or manner of performance of service which is required to be provided by him as per any law in force or as per the contract. Act or omission or commission or negligence or conscious withholding of any information which caused harm. Failure to issue adequate instructions or warning to prevent harm. Non-conformity of the service with the express warranty or terms and conditions of the contract. Regarding the product seller's liability, Section 86 of the Act lists out the instances under which a product seller, that is, who is not a product manufacturer, shall be liable in a product liability action for a harm caused by a defective product sold by the product seller. A product seller, not being a product manufacturer, shall be liable in a product liability action if the seller exercises substantial control over the design, testing, manufacturing, packaging or labeling of the product that caused harm, altered or modified the product where such alteration and modification is the substantial factor for the harm caused, has made an express warranty of the product independent of the manufacturer's express warranty and the product fails to conform to the seller's express warranty causing harm, has sold a product causing harm where the identity of the manufacturer is not known or such manufacturer cannot be served notice or process or warrant or is not subject to the law in force in India or the order passed cannot be enforced against him, fail to exercise reasonable care in assembling, inspecting or maintaining such product or fail to pass on the manufacturer warnings or instructions concerning dangers involved or proper usage of the product while selling such product which proximately resulted in the harm caused. Now, let us look at the exceptions to product liability. Under the new Consumer Protection Act, a product liability action cannot be instituted against the product seller and manufacturer in the following circumstances. If the product was misused, altered or modified at the time of harm, the seller cannot be held liable. If the product was purchased by employer for use at workplace and the manufacturer had provided warning and instructions to the employer. If the product was sold to be used as a component in another product along with warnings and instructions, but harm was caused due to end product which contains such component, the product is legally meant to be used or dispensed only under the supervision of experts. If the complainant was under the influence of alcohol or drug not prescribed by medical practitioner at the time of using such product, such instructions or warnings about a danger are obvious or commonly known to the user or which the user ought to have known taking into account the characteristics of the product. Coming to the consequences of product liability, the 2019 Act empowers the District Commissioner under Section 39 to investigate the product and manufacturer or seller regarding the defective products which harm the consumers and determine whether such liability actually arises or not. Upon satisfaction of the same, the central authority, that is the Central Consumer Protection Authority, which is a regulatory authority under the Act with powers of investigation, inquiry and injunctive actions, may order for recall of goods or withdrawal of such products, replace goods with new goods of similar description free from any defects, return the price or charges paid by the complainant along with interest for such defective product, removal of defect in the goods or deficiency in services, then also to pay amount as awarded by the district commission as compensation to the consumer for loss or injury suffered by the consumer due to the manufacturer's negligence. The district commissioner also has powers to grant punitive damages according to the facts and circumstances, to pay compensation in product liability action, to discontinue offering the hazardous goods for sale and withdraw them from being offered for sale, and to cease manufacture of such goods and desist from offering services which are hazardous in nature. Therefore, the new 2019 Act has fastened responsibility on the manufacturers and sellers for product liability. In view of the above discussion, the following conclusion may be drawn. The 2019 Act addressed the issue of product liability comprehensively and has certainly enhanced the nature of complaints not only for product manufacturers, sellers and service providers, but also on the parties connected with the sale process, including endorsers, importers, marketers and repairers. Recently, there has been an amendment in the Motor Vehicles Act 1988, which has introduced statutory framework for recall of defective motor vehicles. Most notably, the changes are twofold. First, there is now a provision whereby the central government may, by notification, prescribe conditions for alteration of motor vehicles, in which case the warranty granted by the manufacturer shall not be considered to be void. Second, the amended Motor Vehicles Act contains provisions for the recall of vehicles in case of defects. The Motor Vehicles Act also provides for punishment of the manufacturer, importer or dealer of motor vehicles for vehicles which are in contravention of the norms provided for construction, maintenance, sale and alteration of motor vehicles, which may include the imprisonment or fine or both. Therefore, even penal consequences also may arise for the product liability. With the establishment of product liability regime under various statutes, now it is imperative for product manufacturers, service providers etc. to be more careful about the regulatory compliances and to provide for adequate disclosures and warnings, and to take prompt preventive and precautionary steps as and when needed. Dear students, I hope that you have enjoyed watching and listening to this lesson on product liability. We shall meet in the next lesson. Thank you.